conundrum. Nobody told them. You better get that in writing. And here's the woman that you need to know. There's someone you should know. So what do you want to do? I just want to get in the business. There's someone you should know. So do you know who Harry Fox is? Tell me the dude from church with the big nose. There's someone you should know. But where do I need to go? The Professor Butler Show.
Good morning, ladies and gentlemen. My name is Professor Butler, lawyer, lecturer, liberator. I'll be your instructor for today. Welcome to Conquering the Copyright Conundrum, where that's exactly what we're going to do. We're going to conquer the very complicated subject of copyright, but I'm going to try to simplify it and make it as easy and as palatable for you today as I possibly can. Question number four. I must always get permission to perform somebody else's music in the nightclub. So question number 4. I must always get permission to perform somebody else's music in the nightclub. True or false?
I said false.
I
said false.
I said false, but I think it's true now after hearing this presentation.
But then wait, I must have done something wrong because the answer is... Yeah, right, I'm sorry. The answer is false.
Oh.
It is false. Now, why did you ladies say it's false? Why did you say it's false?
Because they don't need your permission to perform.
That's right.
Okay. Okay.
That's right. So when I said I must always get permission, I must always have to get permission to use somebody else's music to perform in a nightclub, and the answer is no, I don't have to get permission. Who has to get permission? The club owner has to get permission.
From ASCAP.
From the Performing Rights Society. From either, well, not either ASCAP, BMI, or CSAC. From who? From all. From all. Because about 40% of all music is licensed through ASCAP, about 40% through BMI, then maybe another 20% through CSAC. So if I want to be able to perform all music in my nightclub or my venue or the University of Memphis, which is a venue, right? I have to have a license with all three. So a lot of times people will ask me, well, I want to come on campus and I want to perform some music, and somebody from the campus will call me and say they want to come on campus and perform a certain type of music. I'm like, they don't need permission from us because we have permission to perform any type of music. So it doesn't matter what they're performing. They don't have to have permission from the Beatles to perform a Beatles song. We have permission to perform anything in the Beatles catalog. Because we have a blanket license is what it's called. That's what they get from ASCAP, BMI, or CSAC. They get a blanket license to perform anything in the catalog.
So when a venue, oh my goodness, so when a venue tells you you can only play original music, they're letting you know right off the bat
they don't have a license. Did you hear that? She asked if a venue says you can only play original music here, what they're saying is they don't have a blanket license with a PRO. That's exactly what they're telling you. You can only play original music means we don't have a blanket license with a PRO here.
Wow.
We are not authorized to perform music from ASCAP, BMI, or CSAC because we don't have a license with them.
Right.
You can only perform your own original music.
Right, but
that's what they're telling you.
So when a club, they have to get a license from these people as
Yes.
well as liquor license?
Yes.
Okay.
Yes, and they can be very expensive. And the licenses are kind of prorated depending on size of the club, capacity of the club, that kind of thing.
So does the publishing go get the club? Oh, so they use that money to pay the songwriter?
That's right.
Okay.
That's exactly right.
I read an article recently that now those three organizations are going aggressively after coffee shops.
Oh, yeah.
And so now, and they're telling the coffee
That's
shops
right.
telling that we only use original songwriters. They're saying no, somebody might sing a cover tune by
Look, performance, and that's because performance it could be performance on the radio. You could be playing the radio. And look, there are small business exceptions. So, and I won't go into the details, but it could depend on the square footage, how many speakers, how many TV sets.
Wow.
This goes for sports bars, massage parlors, coffee shops. If you don't fit within that square footage speakers exception, you've got to pay a license. Because remember the piano, the player piano? Right. The reason the pub with the player piano was paying the guy with the player piano who was then playing the songwriter is because the pub with the player piano got more customers. And the reason you are performing music in your venue is for a reason. It's not for no reason. It's either because your customers are more comfortable, it sets an atmosphere, it sets a tone. You're not playing it, you are getting an advantage for performing music in that venue. So that's why you're being charged a fee. That's why. Who gets this protection? So we know what it is, right? How we get it, how long it lasts, who actually owns it. Whoever creates the work is the original owner. Whoever creates it is the original owner, right? Unless, except when. There's only one exception to that.
Death?
Besides death,
Work for hire.
there's only one exception to that. Work made for hire. Right. So if you created it, you are the original author, you are the original owner. Unless it's a work made for hire, where you're the employee within the scope of employment, or you were specially commissioned to create the work, there's a contract, and it fits within one of those categories. Other than that, you are the original author, you're the original owner, right? Yes?
Does the work for hire contract have to be written?
Absolutely. No such thing as a verbal work for hire. Because there are so many ramifications, legal ramifications behind it. The person who is creating the work has to legally express the fact that they understand that it's a work made for hire. Absolutely. Now, the only way that you can otherwise not be the owner is if you transfer the work to somebody else. And there's only two ways, and the transfers have to be in writing. You cannot verbally transfer a copyright.
No.
Cannot be done. Just like you can't verbally transfer property. You know why? Because copyrights are property. And you know what will really help you with copyright, with understanding it? It's part of intellectual property, which is really part of personal property. Personal property and real property, they're all the same. Like these chairs, and the same rights that you have with your real property, you have with your intellectual property. People can't just walk into your house and do whatever they want to do because there's laws that protect. People just can't stand on your lawn without some ramifications. Well, it's the same thing with your intellectual property. You know, I give an example of where, I have a real ugly car, right? And you may not like my car, right? But that doesn't mean that you just can't come and paint it another color just because you don't like it, right? Well, it's the same thing. If I have a song that you don't like, that doesn't mean that you just can come and remix it at your leisure, right? Or let's say I have a really nice car, right? And you want to advertise some work that you're doing. You just can't come take my car and drive it around town and say you're doing it for promotional purposes.
Right.
I'm just doing it to drive around for promotional purposes. And that should be okay with me. But it's okay for you to take my song and use my song for your work and say you're doing it for promotional purposes? And that's supposed to be okay?
That's where the church got in trouble.
That's where a lot of people get in trouble. People are always using other people's work for promotional purposes. And that's supposed to be okay. Okay, well, let me use your car I got some promotional purposes. Let me use your car for promotional purposes.
So is that
Same concept.
I'm sorry. Is
Yes.
that the same as like club owners using certain actresses or athletes, putting them on there?
Yes.
They do that a lot.
Because you know what? There's another type of intellectual property called your name and likeness, called right of publicity. My image, right? I own my image.
Right.
You just can't take my image and use it for promotional purposes
They do that a lot.
without my permission. Exact same thing. Exact same thing.